Today we're going to start talking about commercial speech. And commercial speech is interesting because a lot of the times we think of it in the same vein as we do freedom of expression, but it is not considered to be an area where there's much freedom of expression. When speech is being used as a profit motive in a sense, right? It's commercial speech, it's advertising, it's entertainment, it's not as protected as speech that's directed at the government or at politicians. And part of the reason for this is that we've decided over time that the airwaves in general, right? So the medium that we deliver the message through, whether it's television, radio, the internet, right? These are all infrastructure bits that have public elements, are owned by the public, are regulated by the federal government, and so they are not necessarily places where you can exercise free speech and say anything you want outside of regulations. And this is especially true when you get into broadcast media, where there's commercial speech is advertisement, the commercial speech is entertainment, right? There are going to be a lot more regulations, a lot more limitations put on what can happen on that, and the broadcasters, the delivery of content, those people that deliver the media, generally speaking, are held to a standard to deliver material that is for the public consumption. Now, some of that varies based upon the nature of the access to the material. So if it's truly public and that, right, you get a radio and you pick it up over the radio waves, you get a TV with an antenna and you're picking it up over or at the TV broadcast through the antenna. Those are truly public, right, in that sense. And so there's going to be more limitations on what can be broadcast there than, say, what can be broadcast on a subscription-based access, where you have to, you actively go out and purchase the access to that material. And so, we're drawing kind of lines in the sand here between who the audience is, how you get access to the media, and how far the government feels they need to step in on our behalf as a public regulator. And they do, right? I mean, there's a distinct difference between what's allowed on TV between 6 a.m. and 10 p.m. and what's allowed on TV between 10 p.m. and, say, 6 a.m. There's even more latitude about what's allowed on, a pay-for-view versus, right, HBO or any kind of cable access or something like that, where you're paying for direct access. There's less regulation there, so there's a lot going on. And if the media actors that are engaging in this speech violate the rules that are put in place that are regulating what the content can be, they can be fined, right? They can have access to their frequencies taken away from them, right? And they pay the government to have access to those frequencies. So it's something they're purchasing and they're acknowledging the rules. And so commercial speech is very different. Even if the message you're delivering through that commercial speech might be political in nature and would normally be something that you could speak about, delivering it to the public in and violating regulations over those public airways could get you into trouble, right? So I've got here a real old example of Janet Jackson in the Super Bowl. If you remember the little bit of scandal that came from that, right? That here we are in prime time on a Sunday evening, and she has a wardrobe malfunction, right? Which exposed her breast to the Super Bowl audience, and um, the FCC eventually fined the broadcast company for that, for allowing that to be on there. And I think it was, I don't remember now. I was about to say how much I thought it was, but I've forgotten how much it was. It was a pretty substantial fine, right? On late night shows, the Tonight Show, things like that, Jimmy Kimmel or whatever. They're able to stretch things a little bit because of the time frame they're in, but they're still subject to regulations about what they can deliver. Was it 500,000? Thank you. So that's substantial for me, maybe not to the broadcast company. Um, but you've got comedians that go on those all the time, and comedians tend to like to push the envelope, and so they can get themselves and get the broadcast networks into trouble. On you got some free time, and if you're not offended by um, you know curse words, look up the 7 words. It's a George Carlin skit called "The 7 Words You Can't Say on Television or on TV," right? Which was a comedy skit that he did on his tour, right? And he got invited onto the Tonight Show when Johnny Carson was a host, and they told him beforehand, "You can't do that bit on live TV." And at that time, there was no delay; everything was broadcast live, and he ignored them and did it anyway. And that got him into trouble. So he's one of the reasons that now there's usually a 5-second delay between what's being broadcast and the actual what's occurring on the set. That gives the studios an opportunity to censor out things that would get them fined. So commercial speech is censored a great deal, right? It is regulated. It is not considered in the same veins as uh, you know the freedom of speech that we get to address and criticize our government, even if that's what we're doing through that commercial speech. Um, so there's a distinction being made there as to what's the expectations that occur on our public airwaves, and so we regulate that an awful lot. So um, does that make sense? Any questions about how commercial speech is different? Is not considered free speech in the same sense as when we're addressing our government directly. All right, well, let's start looking a little bit at where we get ourselves into trouble when we start looking at the freedom of expression and when we start trying to come up with rules about limiting speech, right? Why it's not considered a free for all, even if you are directly addressing the government. And generally speaking, this is going to be true of almost any of our liberties, that when two liberties come into conflict with each other, or a liberty and a right come into conflict with each other, the government, especially the courts, are put into a position of trying to walk a line between them and find the best path forward, right? And it's certainly, there's a lot of cases where these different values that we hold, that we consider to both be important, right, to be things that help make our democracy a good democracy, they come into conflict with each other. And the first one I will look at are cases where free speech or freedom of expression runs into the value of public order, right? Part of a government's job is to provide public order. Part of our government's job is to ensure that we have a arena for free speech. And um, it is certainly possible that your speech as was recognized in the court case of Schenck versus the U.S., that your speech can result in clear and present danger, right, of something happening, something substantially evil happening. And in that case, if your speech is driving folks to a riot or to civil unrest or to civil war, right, the government has a responsibility to provide public order. So they're going to generally draw a line at the point where it crosses over from criticism of the government to an inciting a riot, to say, okay, your freedom of speech is going to be limited now, right? You're not going to let you destroy the country. And this is exactly right the kind of conflict we're seeing right now going across the country, where protest, once it goes beyond just protest and becomes protest that is damaging property or endangering lives, that brings up a concern of public order. And generally speaking, we don't want our protest to, right, endanger life, liberty, and property. So public order concerns will be usually upheld before over, right, freedom of expression concerns. So in that vein, right, we've tried to lay out how we can have free speech, where we can have free speech, and what some of the lines there are, because we do want to protect it, right? Freedom of expression is absolutely necessary for democracy to work. So we've got to be able to figure out how to get that in there. I don't think, let me back up before we talk about free press and free trial and give you an example of this. We're seeing it, obviously. We're seeing examples of this where cities struggle with where do the police get involved, right? At what point is a protest a riot and they need to be involved to stop that? At what, do you step in proactively before something happens? Do you have to wait till somebody gets hurt or property gets damaged? The line there is tough to find out, to figure out. And so, you can see some ugly things starting to take place. And the question we have to keep asking ourselves is, how necessary is that in our society to let it or not, and where do we draw the line? And there's no perfectly right answer to this, right? I gave you a little bit of an example yesterday from the Texas A&M KKK march. There have been even worse protests out there, right? So where you've got people that are marching that are looking essentially to start a confrontation. They're not looking, you can tell that they're not looking just to get a message out. They're looking to insult people, to verbally harass people, to try to instigate something. And so in those instances, it's difficult to see, is that still freedom of speech? Is there expression there that we need to protect, or is this going across a line? And we don't have a solid working answer on this that gives us an answer to apply easily in all these situations. Generally, the perspective is try to be, if you see, right, protesters and then counter protesters at the same place and the same time, you try to drive a wedge between them. You try to separate them. You try to, right, let them both have their say and maybe even get close in engagement with one another, shouting distance kind of thing. But generally, to protect public order, you try to keep some distance between them, especially if you've got history that shows that if you don't, there's going to be a riot, right? There's going to be people get hurt. There's going to be fights. Things are going to get firebombed and things are going to get thrown and people are going to, right? So when you know that that's a very prominent possibility, then sometimes you'll see public order exercises occur sooner than they would have in other places. Again, it's each situation is a little bit different. Right now, it's almost a guarantee if the Proud Boys and Antifa show up at the same time at the same place, they're going to start hitting each other, right? We pretty much know that. We've had enough examples right across the country where they both show up that we know that that's going to result um, in violence. Now, the question that a lot of cities are asking themselves is, well, do we just let them go at it because they want to and try to protect property around them and say, basically, you know what you're getting into, it's your own business, and we don't put our own police or such in jeopardy for that? Or do we try to keep them separated the whole time and not let them get in proximity to each other? Um, Different cities with different experiences are going to come up with different answers. And sometimes they'll be successful in one place and not another. All right, let's move on and talk about conflict with a different set of values, free press versus, would that be borderline profiling? Well, profiling is certainly used all the time. There's nothing inherently wrong with profiling as long as it's not based on race, right? Some kind of protected class, race, age, something like that, gender, right? But if it's based on belonging, if you're profiling based on belonging to a group and previous actions of that group and previous actions between two groups, that's perfectly legal profiling, and that's how you do good police work. So uh, in that case, I would say it is profiling. It's not borderline, but it's legal, right? So um, that history gives you an insight to it that takes it just beyond noticing somebody's physical characteristics and using that as a profile, right? You've got history, you've got action. Bring that, because when there were women activists versus leading male activists. So I guess that could certainly, if the profiling was based on the fact that it was just women versus men, um, and not upon some kind of history or experience, right? Then it would be gender-based profiling. But if you've got as your next sentence says, right, they're breaking the men up before the women, I'm assuming, correct me if I'm wrong, that's because, right, the men would be much more violent than the women generally, would be our assumption. Um, you probably shouldn't assume that unless you've got history that shows it, right? So if they're antagonistic to each other, right? They have been antagonistic in the past, and the men were consistently the ones that cross the line and start the violence. Then you've got some activity based profiling, which is much more amenable than just the fact that they're men, right? Um, so you have to be careful. Right? You have to be careful about it. You have to act with some kind of rationality behind how you're going to prevent that. But again, right, we're not talking about arresting. We're talking about separating. Right? We're talking about keeping them from coming into contact with one another. If I've given one group a permit to march, right? We've agreed, the city's agreed with that group, they've gone through all the right steps to march from here to here at this time. A counter protest group shows up without a permit, right? Then I have other reasons that I can move them on. They didn't get a permit to be where they were. They're not following the rules about protesting, right? About us being able to provide a safe place for them, and we can move them out. If they do ask for a permit, right, the counter protest group, as a city, I'm probably going to try to find a way to grant that to them, but then try to ensure that the two don't come into contact with each other by saying, well, this group here is permitted to march over here. We'll permit you to march over here. And notice there's 2 blocks between you people. We're going to have the police there and nobody goes across the line. That's how you would allow both sides to say what they need to say and still try to protect public order, right? So there are ways to try to work this out. But if it's two groups that just autonomously show up at a place at a time, there's nothing much you can do to stop it. You just got to go over to stop it from starting. You just got to go in and clean it up in the midst, and that's dangerous for everybody, right? Once they start the rioting part of it, it's a riot. You don't need anything there. You're no profiling. You go in and you try to stop the damage to people and property. Yes, makes sense. Any other questions? All right. And if there are other ones that you want to bring to me offline, right? That's all perfectly legit. Be happy to talk about them and see. If I don't know, we'll try to go find something that gives us some guidance onto how it works. Second kind of place where we see the conflict between these liberties and values that come out of our Bill of Rights and such is between a guarantee for freedom of expression for free press, but also a guarantee for fair trial for those that are accused of crimes. Quite often, the coverage that the press wants to give, and especially engaging, salacious, entertaining, whatever, politically prominent trial, can in and of itself threaten the concept of having a fair trial for a person, right? As the press is bringing issues out, informing people about so-and-so's been accused of this, and here's the court, and here's the evidence that's being presented, right? The public has a right to know a lot of those things. But there's a point where if too much is put out there, or there's too much speculation, or if there's the presentation of speculation as fact, that can damage the ability of the court and the jury, especially if there's a jury, of delivering a fair result for that trial. And so we have to be kind of trying to balance, right, what the public needs to know and what they want to know, right? And those are two, and the amount of information that needs to be kept in the courtroom, not sensationalized, used just as evidence for the trial. And this can be difficult to do. One of the reasons that it can be, we have to look at it seriously is, especially in a jury trial, we're probably going to be picking a jury out of the people that are seeing all of that speculation and information through the press. And that speculation, presented as so much of it is today in the media as fact, can certainly bias people to a position before they've actually seen the evidence, heard the arguments, understand the actual law that's to be applied, or to be looked at, and so we have to be careful there. One of the ways that we do that is, if we have a feeling, if the city, the state, the county has a feeling that the press has been so overwhelming in its coverage that it might make it difficult to find unbiased jurors, they will try to move the trial to a different venue where maybe it's not as a big a topic or an issue. This is often quite true where we have a murder trial, right? And the murder was particularly gruesome, and everybody in the locale is, the city there is really riled up about how bad this was and how evil this person must be and how could anybody do this. Might be really difficult to get 12 people that are fair-minded on that. So you move it to somewhere where the people may have heard about the situation. You probably aren't able to keep it from the whole situation out of being heard, but aren't as near to the issue, aren't as close to the affected people, maybe didn't know the people that were involved or something. And the idea is there to try to make sure that the trial that does take place is a fair one, and the result that comes out of it is based on evidence and not on speculation and media coverage. This can be difficult, especially if some of the officers of the court are very comfortable using the media and want to use the media from their perspective or their side. You can get all kinds of stuff that probably shouldn't be common knowledge shared out into the public and exploited as sensational or salacious, and this can be a problem. So that's one place where we have, right, where the press can, through their drive to break a story and to get information out, threaten the ability to deliver a fair trial. The other side of it, quite often journalists are the folks that are digging up sources, people that have something to say or witness something. They're the ones that are out there finding different information that may be important to bring into trial. And they write a story about it, right? And it gets published, and then the police or the court system becomes aware of that, and it's like, well, that's information we need, right? We need to bring that into the court system. And quite often the journalists don't want to give up the sources, the individuals that they used, that they found, to the government, because those people spoke to them on a condition of anonymity, right? Those people spoke to them as off the record subjects, right? So the journalists want to protect those sources so that they're seen as someone that can be trusted by other sources down the line on other stories. And so they want to use I'm a journalist and I have freedom of expression, and the public has a right to know, and it's my job to deliver it. They want to use that argument out of the freedom of expression to protect their sources of information. However, once they release those sources of information in a story, at least release the story, not the people necessarily, then that's information that is possibly out there biasing a fair trial, right? Because it's presented as an argument, well, this is the actual truth. And while I'm not telling you who told me this, you can rest assured that it's someone that's got, intimate knowledge of the situation or was involved with it. And so this is a true story. Well, the courts can't accept that, right? That's what we call hearsay. For a court to count something as evidence, they need to have it, right, from the source. And so the fair trial part of it requires them to try to compel that source to be in the case, right, to be part of the testimony. And if the journalist won't give up who that person is that provided them that, who that anonymous source is, you lose what may be, right, the linchpin witness or source for the guilt or innocence of an individual that's at trial. So it sets up an antagonistic kind of situation between journalists who are trying to, right, hold the government accountable for their actions and bring truth to justice in these situations, and the government trying, right, to ensure that when they have a trial and they bring someone on trial, that they give them a fair one. So it's a tough situation. Now, some states have passed legislation called shield laws. And shield laws are there where the government, the state government, or as has said, we think in general that the journalist, right, bringing the information out is more important in the long run than us having the absolute knowledge of who the subject of the source is. And so that in those states that have shield laws, it protects reporters from being penalized by the court system for not revealing their sources. So they've given, some states have passed these shield laws to give journalists a little bit of free exercise protection in their job. But not all states, right? And states that don't have shield laws are states that have basically said, we're not going to pass a shield law like these other states because we believe that fair trial is more important. And a journalist is someone that's doing an important job for our community, yes, providing information and knowledge, but that doesn't take them out of the consideration of being a good citizen and being, if they're called as a witness, providing the information under oath that they're requested to by the court, which means giving up their source, so that that person can be compelled as a witness to come forward and speak in the trial, so we can get direct testimony from a witness, and we know that under penalty of perjury that person is saying they truly were a witness, whereas the journalist is saying this is what I was told and I believe them. Well, that may be true, but it also is not very convincing as far as evidence in a trial. So there are legislatures that have looked at this as an issue. Some have thought that the protection of sources and knowledge and information is more important, and they pass legislation that are called shield laws. States that don't think that haven't, and the journalist is just yet another citizen, and they'll have to testify under oath. And if they don't, if they refuse to testify, they're generally found in contempt of court, and they're put in jail until they change their mind. And Texas is a state that does not have shield laws, and we've seen several journalists in Texas say, no, it's more important for me to preserve this journalistic integrity and to shield my sources from the government than it is to share who they are with the government, and I'll go to jail. And we've seen folks in jail for months to a year at a time for contempt of court by not following a legal order of the court to give that information up. So that's a choice a journalist has to make if they're working in a state that does not have shield laws. Right? And again, there's no definitively right answer here. You've got two very important values that are coming into conflict with each other and how they're exercised in the real world, and we have to make a decision somewhere in there, right? And depending upon the politics and the perspective of each individual state, we have different states making different calls. Does that make sense? Any questions about shield laws and fair trials? Or if any of y'all are movie buffs, did you ever watch a movie called Bernie? Bernie, not Bernie Sanders, but Bernie. It had Jack Black in it and Matt McConaughey, and it was filmed here in Texas. It was about a murder that happened in Texas, in Carthage, I believe, East Texas, and they made a kind of black comedy out of it. But one of the overriding elements in it is that the city, without giving away the whole story, the city as a whole seems to rally around the accused in that case, and the prosecutor didn't believe he could get a fair trial because everybody was saying they didn't believe it. This person was too good of a person, ain't going to happen, wouldn't convict him even if they did do it. And so they moved the case to a different city where that wasn't right. That person hadn't developed such strong friendships with other people in the city, right? It wasn't universally beloved in the city. Really good movie, right? Based upon a true story, right? A real murder case that happened in East Texas, and it gives you a little bit of an insight into what we're talking about here. All right, moving on. Freedom of assembly. We touched a little bit on this just in passing when we talked about freedom of religion, right? That you can get together with people and practice your religion. But here, when we're focused on this element in and of itself, it's a really strong pillar in what it means to have a free society, right? The right to assemble, right? The freedom of assembly is a liberty that says government can't prevent us from getting together with other like-minded people to make a statement, right? The right to associate fills in here as well, right? So we can come together as groups. Our government can't, right, say you can't meet because we don't like the message that might come out of that, or you can't meet because we don't like who you are, right? We have, right, a right to assemble, a right to come together, right, and meet with like-minded folks. Generally, I don't have much to say about this as other than talking about protests. But right now, with the COVID, we've got a new and unique, at least recently new, issue with this right to assembly, right? Because we've got health prescriptions coming in line that are limiting the size of our assembly, right? How many we can associate with at a time. And we have people that are saying, hey, you can't tell me I can't do that. And we've got the government going, well, normally you're right, but right, we think that the size of your association or your assembly is such that it's going to be a public health threat. So we're limiting that for this other good reason, right? So it's an interesting situation to tease through some of that. Most of the time, right, what we're talking about with the freedom of assembly is the ability of a group of like-minded people to get together so that they can protest, right? They can make a political statement. And the government is in a position, right, under the freedom of expression idea that you need to let them make a statement. And part of being able to make a statement is to get together as a group so that it carries more weight. That's kind of the whole idea behind democracy. So you need, as a government, if you're going to be fair and democratic, to let people get together in groups, try to organize their message, to organize themselves as a group and deliver that message. In other words, you got to let people assemble. And that means protest, and that means marches, and that means to be out in public, right, telling people what you think as a group. Generally speaking, we want that right to assembly to be as unfettered as possible, right? We want that to happen whenever people think it needs to happen. However, right, the court has given us some restrictions over time about how this needs to go, how this needs to happen, right? Ways to help protect property and people and from these assemblies or from these assemblies getting out of hand, which we touched on a little bit just a minute ago, where I said maybe through the permitting process you have protesters and counter protesters separated by some distance. What the courts have told us is that, and generally it's cities that are having to implement this, that when you're looking to allow a group to assemble, that the city or the governmental authority has some right to restrict that. Those rights are referred to as time, place, and manner restrictions. Those are restrictions that are going to be there to make the assembly safe for both the protesters, maybe the counter protesters, the property that's around it. Right? The idea being that you want to give people the place and the opportunity to speak their mind, but you also want to make sure that it doesn't go crazy on everybody, right? So what's in place is called time. What is there as a limit is called time, place, and manner restrictions. So essentially, you want to protest, you've got to get a permit, right? You want to have a march, you need to get a permit, and so you'll go to the city. The practice in the city is to grant permits as liberally as possible, right? That you're supposed to, as the city government, say yes. Now you have to look at what's being requested for the protest. So let's take Austin, for example. In Austin, if you want to see and be seen and get your message out there, right, the place to kind of do it is Congress Avenue, right? You march down on the Congress Bridge, you march down Congress Avenue, it leads you right up on the state capitol's lawn, and you have your protest rally on the lawn, right? So you do your march and you have your protest. And that's recognized, right? The city of Austin's like, yep, Congress is a place to do that. It'll get you what you want as far as exposure, visibility, and they'll take care of ensuring that it's a safe place to do it, which means they're going to shut down Congress Avenue from the bridge all the way up to the Capitol. No traffic crossing it. People are going to have to stay on the sidewalks, and those protesters, right, going to be able to march right down Congress to the Capitol. That's pretty much the accepted practice. Right? Now, to do that, right, they're going to want to make this a reasonable kind of situation. Do you allow someone to march down Congress Avenue? Do you shut down, right, the most prominent street in downtown Austin between 8 a.m. and 5 p.m. on a workday? There's an awful lot of people there that's going to have their property damaged if people can't come to their businesses. And so what they generally try to do is they try to schedule it around some of those, right? So weekends, after 5, things like that. They'll still shut it down, right? But they're going to try to balance both concerns at the same time. We see other protests that happen spontaneously. Most of the time when those kind of protests happen spontaneously, the city tries to manage that spontaneity so that it's safe, right? And right can actually happen. Sometimes though it's just not possible. If you remember, I think was it earlier this spring or last fall? I don't remember. There was protesting that shut down I-35 at 5 p.m. Right, folks basically walked out onto the freeway, right? I-35 going right through the middle of downtown. They walked out on it and shut down traffic on the interstate highway. They didn't have a permit. It was spontaneous. That's not going to be allowed, right? That's not ever going to be something that is considered reasonable. It's dangerous to everybody involved, and there's not much you can do to make it less than dangerous. They're not going to let you shut down a federal interstate and march on the interstate in almost any circumstance. So those folks were arrested, right? Because they were protesting without a permit, and they were arrested for probably disturbing the peace and protesting without a permit. Right, and most of us would look at that and go, yeah, that's kind of going beyond the bounds of all reasonable considerations. If a spontaneous protest happened down at the Capitol, right, on Capitol grounds, probably what you're going to see there's the Capitol Police just trying to make sure that it stays safe, right? They probably won't be arresting anybody because that's considered a public place of free speech, and that's normally where you want it to happen. And okay, they don't have a permit, so that's not good, but it's probably not going to get them in too much trouble, right? Again, the city needs to be reasonable in the way they approach these things. Most of the time, the restrictions they can put on it are time, place, or manner, right? Meaning when you do it, where you do it, and how you do it, right? Now, those are the limits they'll put. Not that you cannot do it, right? But so if you go down to Austin and say, we want a permit to march down I-35, you're probably going to get a no on that. And they're going to try to probably, instead of saying, no, you can't protest, they're going to say, you can't protest there, but let's find you another place that you can. right? And so that's what they're looking at, and that's the focus that cities have tried to put into place, and the courts have backed them on that, right? That time, place, and manner are reasonable restrictions. Again, if you know the Proud Boys and Antifa are going to show up face to face, and you know by history in your city that they're going to fight, you can limit that because it's going to be a threat, right? It's a dangerous situation, and you can just say no, no, right? We'll permit one of you, and the other ones, if you show up, right, you better not get within. And so, there's ways of managing it. On the other side of this, though, is the fact that is the right to association, and association simply means that you have the right as a citizen to associate with people that have common interest. Now, this doesn't necessarily mean that you're going to assemble for making a statement, right? That you're going to protest or march or get out. But it's a protection for you to have the ability to get together with people that are like-minded and have a meeting and talk with each other and work with each other and befriend each other. Right? The government can't say that you can't do that, and this is why we see groups, right? Race groups, hate groups, right? Allowed to get together and to exist, right? The right to associate allows them to be there, allows people, whether you like their who they are and what they want to talk about, it's not illegal for them to associate. As a matter of fact, it's protected that they can associate. And as a private group, especially on private property, it's not the government's job to be involved in limiting that association, as long as what they're doing when they associate is in and of itself not illegal, right? As long as they're just associating. So this is why we can still have private organizations that are racist in nature, or misogynistic in nature, or anti-religious, or non-religious, whatever the right word there is, right? So we're protecting the rights of all people to associate with people that share a common interest with them, even when those common interests are maybe repulsive. And so that's not, the government actually has to protect that. And one of the examples I like to bring out it's not old in my memory, it's a little older than probably most of your memories, is I'm a golfer, so this is not a gopher, but a golfer, right? This is a situation that stood out in my mind, and it's this probably about 1990. The Pro Golf Association, right, the group that holds all the pro golf tournaments, had scheduled the U.S. Open to be at a private country club in Alabama. And no, it wasn't the U.S. Open; it was the PGA Championship. But regardless, it was scheduled to be at a private country club in Alabama, and that private country club was a whites-only country club. Now, the fact that there's a country club, a golf country club that's all white, is protected by this right to associate because it's private, it's not public, right? It's people choosing who they want to associate with. So there can be this group of people that want to associate with other people that are the same skin color, and they can do that. And the PGA, I don't know what was going on in their mind, but they scheduled this tournament there. And Tiger Woods, right, the reigning PGA champion, I think, at the time, and definitely the biggest draw on the PGA Tour, just simply said, nope, not playing there. Because he's got the right to associate or not as well. And he took a stance. And a lot of other PGA professionals, after seeing that, took the stance with him. And the PGA got the message, and they moved their tournament, and they put in, right, rules within their own association that they would not hold golf tournaments at places like that anymore. Now, what happened that was even a little more interesting is that club immediately changed its bylaws and immediately opened itself up to members of all racial perspectives. And they brought in new members. And they're still now, right, a golf club that lets people in there. So this led to a really good result. And it actually allowed the tournament to actually, if I remember right, the tournament actually did go there, right? Because they changed and kept the change. And so it led to real change in society. But the government, no involvement at all, because everybody here was exercising their right to associate, and it was private. Now, when we get to the chapter on civil rights, we'll talk about how there's a very big distinction between associations that are private and public in nature or commercial in nature. So we'll talk a little different when that comes up and how that does bring the government into that situation. Well, it is just silly. There's no doubt about that. But it's not against the law. It's definitely not against the law. And so these are the kinds of things where, assembly and association, they're very strong rights, all coming out of this First Amendment that the federal government and more recently state governments and city governments are protecting and propagating, right? In the sense of trying to make this a place where we can exercise those rights on a better, more consistent basis. And it's not always easy, and we don't always make the first right decision, that's for sure, if we look at our history. But I think we're tending to the right direction as we keep going through this. It's just, changing people and perspectives on a lot of these issues are hard. It's very hard. And so most of the time we see the government, right, looking after these liberties that are here and trying to find at least a rational way forward when we get collisions or we get two of these rights or liberties conflicting with one another. All right, so a good chunk of our civil liberties revolve around the rights that defendants have when they're charged with crime, right? When you look at the Bill of Rights, you're seeing a number of them there that are saying, here are the protections that are going to be given to people when the government is accusing them of breaking a law, right? So the criminal justice process, defendants' rights are a large part of the civil liberties that we have. Again, just like with these other big concerns out of freedom of expression, right? We're moving on now out of Amendment 1. Originally, they applied only to the federal government, right? And then they were incorporated down over time to extend out to the states as well. So what we see here are the court cases where we see defendants' rights being protected or extended. So we're going to start with unreasonable searches and seizures, which comes out of the Fourth Amendment, right? That you will not be subjected to as a person subjected to unreasonable searches and seizures. What that means is that when it's not that you will never be searched and or seized, right, arrested. It's just that when the government exercises those powers as part of a public order exercise, they will conduct reasonable searches and they will arrest you based on reasonable grounds. And so it becomes, right, a burden, in a sense, a proof that the government has to make that they did this constitutionally, that they conducted a reasonable search, they conducted a reasonable seizure of evidence, or a reasonable seizure of your person, right? So the Fourth Amendment is our guarantee that the government will not do this unreasonably. What we have then are examples of in court cases where the particular facts show us that it was a reasonable case or an unreasonable case, and the court's explaining why. So to have a reasonable search, right, which is, it's easier to describe a reasonable search than an unreasonable one because there are 1,000 instances of unreasonable ones. A reasonable search happens in two ways. One, right, officer, right, has probable cause. In other words, they have evidence, witnessed something, saw something, something occurred that gave them, right, and any reasonable person the belief that a crime is happening or is about to happen and that you know what's going on. So you have probable cause, some event that raises that issue up, and right, that probable cause can then be taken to a disinterested third party to get a search warrant. And you use that probable cause to say, here's what's going on. Here's why we need to search. Here's why we think we're going to find what we're going to find. And a search warrant will list those things, right? There was probable cause rendered to a judge that at this time and place a crime may have occurred and that there's evidence existing here that will prove that. Okay, so a search warrant is going to have that kind of information in it. And if a police officer is granted, right, a government authority is granted a search warrant based upon the legalities that a judge is supposed to follow in issuing one, that's a reasonable search. Okay. Now, there are times when telling everybody to stop and hold on, let me run down to the court, to the judge, and get a search warrant is not feasible. So searches can be conducted without a warrant and still be considered reasonable. Probable cause still must exist, which means, right, for the person that's going to execute the search, they're going to have to prove their case on the backside that they had probable cause before they searched. And, right, I think the search is necessary, one, either to protect people or to protect evidence, right? So, in other words, there's either a safety issue or a time issue that prevents you from being able to go get the warrant that you have the probable cause for. And so you're going to be required to present all that and defend it at the front end of a court case that the search you executed was reasonable, even though you didn't have a warrant, because, right, probable cause was there, and if you didn't search them, you might have been in danger, and or they may have disposed of the evidence that you were aware was there at the time. Okay, so that's the general perspective of how we're going to do this. In all other instances, right, pretty much what we're talking about is if you search and or seize evidence or people, you're doing it unreasonably if you're not following one of these two paths, right? And even if you are following them, you can still obviously make mistakes and it cannot hold up in court. But these are the two ways that you should try to get there. As a way to try to make these two paths functional and to put a limit on just, right, somebody doing it on their own as a wild card, we have what is called the exclusionary rule that's been put into place by the Supreme Court that tells us anything that you gather illegally as evidence, right? In other words, meaning you do not have probable cause and or a warrant and the right circumstance, anything you grab illegally that's going to try to prove your case, we're going to exclude it, right? If we can determine that you did this improperly, you can't use that evidence to prove your case. It's called the fruit of the poisonous tree, right? The tree is the illegal search. The fruit that you wanted to use as evidence, you don't get to use. So illegally seized evidence, right, is going to be excluded from a trial, which usually means that your case against that individual is going to fall apart. There are exceptions being made to this exclusionary rule. One is that your illegal search was irrespective of it being illegal, you would have found the evidence anyway, right? You can prove the case that yes, maybe we didn't have probable cause, but it was laying in plain sight, right? And we saw it anyway, right? You might have some argument to make that where it's you're not going to throw it out on a technicality in a sense when it was pretty blatantly is that it was there anyway, that you would have discovered it regardless. Again, you should be as the government making this case at a disadvantage before the court because you didn't conduct a proper search with a warrant. It's supposed to be excluded. You're going to have to make an exceptional argument to get the court to believe, right, that it would have been discovered anyway. The second exception is when police are acting generally in good faith. They have what they thought was a valid warrant. They exercise it, and then the warrant is found to be invalid after the fact. This was put into place, and you may have seen TV shows do this where, the police execute a search warrant, they go into a house, they get evidence, it goes to trial, and some eagle-eyed defense attorney goes, Your Honor, this warrant was not for the house that they went into. It was for the house next door. So this warrant didn't give them the permission to go where they did, right? Some kind of clerical error like that, where it was supposed to be, right, one house, the police knew what house it was, they described the house they were going to go to, right? They had all the evidence there that that was the right house. They gave the right information to the clerk to write up on the warrant, and the clerk messes it up. That's not going to invalidate, right? That clerical mistake's not going to invalidate the otherwise valid warrant, right? They went to the right place. They did all the right things. They found exactly what they expected to find, where they expected to find it. No typo is going to get that thrown out any longer. It used to, right? So that's been changed. So those are a couple of the exceptions to the exclusionary rule. When we train police officers, we train them hard on understanding and knowing what good evidence is and how to seize that evidence properly. Doesn't mean they always do it, but they are well trained in it. So this is the searching and seizure bit, right? So it's important because this is something you may actually experience in going, in your daily life, especially if you're pulled over on the side of the highway, right? One of the things that you're probably going to experience sometime, I know I have, and I know a lot of people that I know have, you're going to get pulled over for doing something illegal on the road, stoplight, something, speed limit. Police going to pull you over, brake light out, something. They're going to pull you over. And they have, right, let's assume in this case that they're pulling you over righteously, right? You do have a tail light out, right? They're pulling you over. Not that they walked by and knocked it out on the way to talk to you. And so you get up there, right? The police officer gets up there and says, "Hey, pulled you over for this reason." Let's assume that's all legitimate. And then they ask you, right? They say something like, cars driving this stretch of the road at this time on a Friday night are almost always coming from this liquor stop, and you aren't old enough to be drinking. I'd like to search your car. Can I search your vehicle? This, again, is, well, okay, let me give you a little background. I used for the Commission on Law Enforcement, and I wrote training material for police officers, and we coached them to ask this question, right? We trained them to ask you. And the reason we do that is because if you say yes, they don't need a warrant. If you give them permission to search your vehicle, they don't have to have probable cause. They don't have to have a warrant. They don't have to have anything. They've got your assent. So we, right, as a matter of practice, tell them ask. Somebody's going to say yes. And shockingly, a lot of people that shouldn't say yes do, right? I can't tell you how many times we've had police officers tell us, hey, we started asking, and I had this dude that had a lot of drugs in his trunk. I asked him if I could search his car. He said yes. And so there it was, and we arrested him. So if you give them permission to come into your house, to search your car, to right, to look where they wouldn't otherwise have a valid reason of looking, that's all they need legally. So my my advice to you is never ever give them permission to search anything. Good cops will have probable cause and the ability to get a warrant. Bad cops are going to make something up. So just say no, right? It's a little different application of the just say no, but just say no, right? They don't need you helping them, right, in any way, form, or fashion. That's their job to do that. Let them do their job. You look after yourself. Um, Now, again, I say this from an academic perspective and from a not being in your shoes and in your place. So you'll have to make your decision on how you do things and what you say and what you want to try to live with as you go forward. Um, as a middle-aged white guy that's been to law school and worked with cops, it's easy for me to tell a police officer to back off. Um, that's not the case for everybody. So just because I'm telling you how I would do it and what I think is important, you got to still make this assertion and this right calculation on your own for yourself. But the legal fact of the matter is, if they don't have probable cause and you don't give them permission, they should not be searching. Now, if you remember, right, this part right here, I'm sorry, if we go back one slide, um, this part right here changes things just a little bit, right? The idea that if the search is necessary to protect the police, what that means is a police officer walks up to you after pulling you over in a car, and they think that they just saw you stash a weapon, or that they think they see a weapon within right where you could easily grab it, right? They're going to search for that weapon, and they have the ability, right, to protect themselves and to secure a scene so that they can not have to worry about uh, their own health. Uh, this is can be abused, and I'm sure is abused, but it's also legitimate, especially if you're right as if you could put yourself in the shoes of a police officer walking up on a car in the middle of the night from behind. I've done this. You know, you can't really see anything much below, right? What's illuminated by your car lights, right? That's behind the car you've pulled over. So police officers are, whether that's warranted or not, usually fairly nervous walking up to a car, and especially in the night, but anytime really, because there's a lot that they can't see. Um, and their anxiety level is very high. And so is yours, more than likely. This is never a good mix for a calm, deliberative discussion between people when everybody's anxiety is real high. And part of it's based on fear of each other and, right, unbridled speculation. If you can reduce anxiety in this situation. And I would encourage you to do three things. Keep your hands on the steering wheel, roll your window down, turn on your interior light. right? That goes a long way to diffusing a situation that can go sideways real quick. And if you can find it in yourself to be respectful in your discussion, that could help as well. No guarantees you're going to always get respect from the other side, but just a little bit of advice from someone that's been on both sides of that. Right, the search can happen your immediate vicinity, which means anywhere you could reach sitting in that car. That does not extend necessarily to the glove box or to the trunk, right? And so you don't have to just give away the farm there.